Hi, my name is Paul Norris. I'm an attorney with Stark & Stark in the Probate Litigation Department. And here today I'm to discuss some potential issues which may arise in the context of contesting a will. The first thing we're going to talk about today is in general what's involved in contesting a will. Now, we all know it's always a very sad situation when a loved one passes away in your life, whether it's a brother, a sister, or your parents. And hopefully the estate plan passes through nicely with everybody being satisfied as the current format of the last will and testament, or if there's no last will and testament, that everybody's agreeable to distributions. But if there comes a time, whether you're the executor or whether somebody else is an executor and there's an issue with the will, what may happen is a will contest. And in order for there to be a will contest, there's a few things which must first take place. Obviously, the loved one must pass away. The next thing would be is that you would see a copy of the will, or perhaps maybe an executor refuses to give you a copy of a will. Once the will is admitted to probate and you provide a notice of it, what you must be aware is that there are strict guidelines to contest a will. In order to contest a will, if you live in state, and in state it means the same state in which the decedent passed away, there is a 4-month period of time to contest the will from the date the will is admitted to probate. And what that means is when the executor brings the will to the county surrogate, it's considered admitted to probate after a letter testamentary are issued. If you reside out of state, it's up to 6 months from when the will is admitted to probate. In either case, there's a 30-day extension for good cause. However, we don't like to use that unless we have to. So the first thing to be aware of in contesting a will, you have a very short limitation of actions, which is really one of the shortest in all of in law. The next thing you need to know is who would have standing to contest a will. Obviously, if you are directly related to the decedent such that it's your parent or your brother or your sister, or even if you're the beneficiary on a previous will that this individual drafted, you'd have standing to contest a will. And what standing means is you'd have the ability to file suit. For instance, if somebody unrelated to me, who I had no blood relationship, passed away and I wasn't a beneficiary under the previous will, I wouldn't have standing. Whereas if my parent passed away, and even if I wasn't listed under any previous will, I would have standing. Another explanation would be is if an uncle passed away, and I may not otherwise have standing, but I was a beneficiary under a previous will, and in the current will I'm not. Those are kind of examples of what standing would be. The two main causes of action that are typically asserted in a will contest are undue influence and lack of capacity. What undue influence means, and this is typically what you see whether it's in a made-for-TV movie or just people talking about it, and that means that a person has exerted such influence and control over the person that passed away that the will's not a true reflection of their intent, but instead the intent of the bad party here. And what that means in a will contest is perhaps whether it's a sibling or another individual comes in, the will is changed, and there's a drastic change to the will, and it appears to reflect the intentions of this party rather than the decedent who passed away. So that's one cause of action. The next would be is lack of capacity. And what that simply means is that the decedent lacked the required capacity on the day the last will and testament was executed. What does that mean? It means that the decedent was unable to understand the possessions they had and how their conveyance under the last will and testament was going to take place. It's a fairly low burden to meet. So a lot of times what you'll see is a combination of undue influence and lack of capacity claims, because typically people are more susceptible to undue influence when their mental conditions are a little bit lower. But they are separate causes of action, but a lot of times they're in tandem. The proofs involved in litigating a will contest typically consist of medical records, which have to do with capacity, witness testimony, which a lot of times is the attorney who drafted the will, is an essential witness. People who were present when the last will and testament was executed are essential witnesses. As I said, medical records, doctors, nurses, or whatnot who may have observed the decedent around the time that the last will and testament was drafted. And finally, you really have the fact witnesses, which would be witnesses who observed any interactions between the decedent and the quote-unquote wrong party here, the person who might have exerted undue influence. For instance, it would be, everybody hears maybe the maid got everything. Well, maybe there were observations where the people witness the maid exerting this control over the decedent, you almost acting as a puppeteer in a sense. And that's the type of situation where witness testimony becomes relevant. A lot of times you'll look at financial records, which may reveal the assets, any strange changes in the disposition of assets which might support a claim of undue influence or lack of capacity, and then of course, as I said before, medical records. Now, the question is, what happens if you're successful in invalidating the will? Let's say you go through a trial and the will is invalidated because one of these claims was proved. The question is, what happens? Well, really two things could happen. First would be, if there was a previous will which is deemed valid, the court could then probate the previous will and the proceeds can be distributed in accordance with that previous will. The other option is if the person was intestate, which means they are deemed to have died without a will, and then the proceeds of the estate are distributed in accordance with the statute. Now, it's important to know what may happen if the will is invalidated, because under intestacy, you could do worse than the current will, you could do better. Or the previous will, you could do worse or you could do better. So it's important to look at both of those factors to see if it reverts to the previous will, what's going to happen. If it's intestacy, what's going to happen. At the conclusion of probate litigation, if you're successful in challenging a will, or if you have a good faith basis, you may be entitled to your counsel fees being paid. What you should know is that the person who is representing the estate and defending the estate in any will challenge is going to have their counsel fees paid by the estate. That could potentially be reversed if it's proven later that the will was changed by undue influence. An application could be made to have them pay the counsel fees back. However, typically they're going to be paid. And as you can see by this blog, the process of contesting a will is a fairly complex process. It is something that requires evaluation of medical records, financial records, witness testimony, and a multitude of other factors. It's suggested that you consult with an attorney, whether it's somebody like myself at Stark & Stark or any other attorney who has some experience in this area, because the statute of limitations is very short, and also what's necessary to successfully prosecute a matter of this is complex. Thank you.